The next panel is entitled Legal Issues with Extensions and the DSPAC Process. I'm Steve Nelson. I'm President and Chairman of Continental Stock Transfer and Trust Company. I will mostly be your moderator. As you know, Continental has been in this business for a long time. We've done 1,300 SPACs and 700 business combinations, so we have a little bit of experience. But equally experienced are our panelists, and I'll have them introduce themselves individually, and then we'll go to questions and answers. Mark?
Thank you. Hi. Thank you, Stephen. My name is Mark Indalia. I am the co-chair of the corporate practice at Glaser Weil, a full-service law firm based out of Los Angeles, California. I have not done 1,300 SPAC deals, but I've done my fair share, and I head our capital markets group. I'm also the president of the Small Public Company Coalition, which is a trade organization that represents the interests of the small business community, doing advocacy work with the SEC and Congress on issues related to the small cap market, including many of the issues that have arisen over the past few years relating to SPACs and the DSPAC process.
Thanks, Steve. Thanks, Mark. My name is Finn O'Hegarty. I've been working with Cayman SPACs for over a decade. I work for Maples & Calder, Cayman Islands law firm. It's the largest law firm in the Cayman Islands and also the law firm that's done the most number of Cayman SPACs.
Good afternoon. My name is Carla Amenine. I'm a partner at CFGI, which for short, Corporate Finance Group. I think I'm the lone accounting, finance, consultant advisory person on this panel. We help companies through, in terms of the DSPAC process and the SPAC IPOs. So.
Thanks, Carla. Allie?
My name's Alexandra Lowe, coming in from Cayman Islands at Appleby. We're a full-service law firm in Appleby and 9 other jurisdictions. And we do quite a few work on the SPAC IPOs as well as on the DSPAC, so the market practice, capital markets and M&A, and a lot of private equity work.
And last, but definitely not least, Desiree?
Hi, I'm Desiree Carlo. I'm from Laurel Hill Advisory Group, and I head the SPAC department, which focuses on the proxy solicitation and getting the SPACs through their extension meetings and business combination meetings and
Great.
To the finish line.
Thank you. So we'll start with you, Mark. Maybe you could walk us through the key legal steps involved from the moment a company decides to de-SPAC through on to the end and the closing.
Great. So once a company has decided that they want to go public via a SPAC transaction, the first step is you negotiate, you identify a SPAC that's looking for an acquisition, you negotiate the terms, and it's usually embodied in a letter of intent, and it's ultimately a merger transaction. So you're the target, and the SPAC is the acquirer, at least for legal purposes. And then once the LOI is signed, you start sort of a dual process, one of which is the merger process, and one of which is the going public process. And you do them somewhat simultaneously, where you're negotiating with the SPAC sponsors the terms of the merger agreement, which can be a very extensive, 50 to 100 plus page document with reps and warranties and covenants and closing conditions and indemnification, well, not so much indemnification, but the things that you're going to do once you sign the agreement up until when you close the DSPAC deal and become a public company. The merger agreement process is a negotiation back and forth about the terms and conditions of that merger, as well as the beginning of the true due diligence process, legal, financial, business, that the SPAC will do and that you will do, not only to satisfy each other about the relative statuses of your two companies, but also in preparation for once you sign the agreement and announce to the world that you're de-SPACing into, SPAC, into the SPAC. And so the signing occurs, there's an announcement, and that's really the first time the public hears about your transaction. And then the next part of the process is really to prepare your disclosure document, which is typically an S4 or an F4 for foreign public-private issuers, which is a extensive registration statement that is really akin to an S1 for an IPO, but it actually has some additional disclosures relating to the SPAC negotiations and other matters relating to the merger that you wouldn't necessarily normally see in an IPO document. But you also still have to tell the world who you are, what you do for whom, all the risks associated with your deal, and then things about executive compensation, your corporate governance, and of course, last but certainly not least, your financial statements, your statements of operations, statements of income, and balance sheets, which have to be audited, and with that, what they call pro forma financial statements showing what the combined company looks like. And then once you file that, you go through SEC review, you go through the comment process, you respond to comments, you do a back and forth with the commission. Hopefully, if things have gone well, 1, maybe 2 rounds of comments, sometimes more, and eventually you will clear comments with the commission, at which point you are free to have your shareholder meeting, which is where you ask the SPAC shareholders to approve or disapprove of the transaction. And if they approve, then you move to closing. And an important part of that is SPACs are structured so that the original investors in the SPAC IPO have what they call a right of redemption, where they have the right, if they don't like the transaction, to get their money back from the IPO with interest. And in prior generations, that redemption number was relatively low. People may or may not remember when it was routine to have 10, 15, 20, 25% redemptions, and everybody else stayed in the deal. When the SPAC bubble, for lack of a better term, burst, you started to see massive redemption rates, 80%, 85%, 90%, 95%, where everybody just wanted their money back, but the party still wanted to move forward with the deal, and then they got into various alternative structures to try to push the deal through. Typically, it would involve raising capital via a PIPE, private investment in public equity, along with maybe some other backstop arrangements to make sure that there was enough shares in the float that you continued to meet the NASDAQ or NYSE listing requirements. And then when that's all said and done, you close, and voila, you're a public company.
Sounds easy. Any questions before we move on? Yeah, it occurs to me it probably would have been a good idea for Mark to do his overall overview earlier in the conference, because we've had some more complex issues piggyback, and some of the fundamentals may not have been covered, but thank you for that. Now we'll switch to Ali, since Ali has expertise in Cayman law and the specifics of that. Can you walk us through the common de-SPAC structures that you've seen recently involving Cayman entities, Ali, and what are some of the key timing issues or steps to be aware of in the de-SPAC process?
Yeah, thanks so much, Steve, for the question. Great. It's a good question to start off with. I think there's a lot of value add that comes on the Cayman side of things. I think one thing that stands out in particular is just to be involved at the beginning of the structuring and the beginning of the calls with all the members involved. You have all the different service providers, the client, as well as, other members that are working on the structuring team. And I think one of the value adds there is there's certain like timelines that need to be met on the Cayman side of things. So whether it's, you know, on consents, resolutions, certain filings with the Cayman registrar and so forth, that just need to be set out ahead of time just to ensure a smooth process. I think some of the, you know, the different types of structures that I've seen and I've worked on, one that closed recently, is where the target entity ends up being the top co, the listed company. And I think with that, you also have a lot of other entities that can be involved on the Cayman side. So you'll have a merger sub or another sub that's incorporated within the structure, and that's for tax optimization. So it's always led by the tax structuring team, usually on, we call it offshore counsel, so either, you know, depending on the transaction, US or UK, we'll work with. And so once we incorporate those entities, we work on certain contribution and exchange agreements and so forth. And so all of those type of preliminary steps through the tax structuring, through the different service providers that provide us with this type of structuring, we map out the checklist on the Cayman side. And I think what's really important is to also involve at the time is the board members that are going to come on. So sometimes we'll do presentations to the incoming board, especially if it's going to end up being a top co, and they want to make sure they go through their fiduciary duties, as well as all the consents. There's certain policies that, you know, that's required on the exchange, whether it be NASDAQ or from the SEC. So we make sure those consents, and they're well aware of that. And then just to work from, you know, back in terms of like if we're basically structuring where there is like another Cayman merger sub that is going to merge into the target entity, and then either like a reverse merger happens, or it's basically going to be the target entity and then the SPAC is a wholly owned sub of that entity, is that we have statutory mergers that come on the Cayman context, and those definitely have to be, you know, usually pre-approved, or at least you know the filings that have to occur, because on the day of closing, you'll have 1, 2, 3 different types of mergers that happen consequently. And one, for example, if there's, you know, a second merger that happens after the Cayman merger at the day of closing, you'll either have to give that Cayman merger certificate or confirmation from the registrar, which we just went through last week. And so it depends. The US exchange might require that. So it's just, these types of things are just really important to note out, either in a checklist when you're working with the different councils, and just to think of all of this ahead of time and all the approvals that have to happen on the day of closing. Another type of structure is then when you're going to have a reverse merger, and then the target, well, it's actually going to be where the Cayman entity is going to be a wholly owned sub of the SPAC, and so then the Cayman entity can still continue, because again, tax optimization structure, you may not want to liquidate the Cayman entity, because then there's going to incur and trigger certain, for the investors, certain tax issues, so you might want to keep that entity involved. So I've also seen that as well. And then the third is sometimes, you know, you'll deregister from Cayman to another jurisdiction, usually Delaware. And another point I think that's important to note in all of this is at the time when you do have closing, no matter what structure it is, if you're going to amend and restate your articles, which is basically the charter, the organizational documents, is to make sure that certain terms are very important to include in that, so there's no issues when you actually happen at closing. And, you know, because of the transaction or whatnot, you might not want to have certain terms and certain provisions in those articles. You know, one is board consents, another is shareholder rights, another is sometimes like at a SPAC IPO, depending on the IPO, you'll have redemption limitations, so that might want to be taken out. So you have to make sure that you go through, like whether on the Cayman side with your offshore counsel, US or UK, to make sure all of these things, especially in the articles, you know, they reflect the transaction, the current one, and there's nothing missed. You don't want to have anything missed. You know, want an efficient process, and so you really do have to think ahead. I think having been through a lot of these on the de-SPAC side, a number of these transactions over the last couple of years, and speaking directly with clients and so forth, you start to understand, you go, and I think from my perspective, what I've learned is the more conversations, the more you have at the beginning, as well as through it, just to make sure that everyone's aware if terms change or whatnot, that all the parties are involved. So I don't want to take up too much time, but that's what I would say.
Great, thanks, Ellie. Any questions that are specific to Cayman entities or not? I have a surprise bonus question for you and Finn. So how did your practices in the Caymans change after Treasury decided to pass their excise tax?
Insofar as the shift from Delaware because of the tax on redemptions,
Yeah, you're the belle
it
of the
shifted
ball
in a
now.
positive way, Steve.
Yeah.
So that's why there's 2 Cayman lawyers sitting up here this year, and there wasn't the same 2 last year.
Yeah, so I assume you have more lawyers and more hours billable for SPACs.
I'll tell you that at the beer truck.
Okay, very good. All
Thanks
right.
for the surprise question.
No problem. Okay, so we'll jump then to Carla, and since we're in the DSPAC process, give us a summary of what potential registrants need to know when it comes to filing for financial sections for regulatory filings.
Sure thing. I think Mark mentioned a bit about, kind of spanned a bit about the financial statements that you might need and also Article 11 pro formas. I think as we start to think about recent years, the SEC has put out rules and regulations that essentially is trying to make consistent the DSPAC process and regulatory requirements needed with their traditional IPO. So in that process, normally when I think about this is it takes a normal company about 12 to 18 months to go public, give or take a few. And as a SPAC company, you usually have 18 to 24 months to find a target. So while you are going through the process of finding a target, and as we're talking about extensions, one of the things I always recommend is just to make sure that the target company that you are looking at is, depending on where you are in your 24-month timeline, the target company is probably one that should have already had audited financial statements or at least advisors in place to be able to quickly get you audited financial statements to the right standards, the PCAOB standards. One thing I also noticed in the last couple of years in terms of what people need, in the past, PIPE transactions, the PIPE market was a little bit more, open. So but currently with the high redemptions, a lot of target companies have issues trying to find a PIPE to go with the transaction. And if you have high redemptions, no PIPE, you've got to find different ways to be able to fund your company going forward. So there are a lot of agreements that come out of a de-SPAC process. So with that said, usually if you're looking for a target company and you have ancillary agreements, that is whether it's ELOC or FPA or convertible debt agreements, whatever it is, there should be time baked into that to make sure that, I always say it's kind of an audit before an audit because those transactions have to show up in your pro formas. So there should be time baked into what you're thinking of so it doesn't mess with your extensions to be able to get through those agreements, have the auditors take it to the national office, and have that implications be reflected in your financial statements and your pro formas. Another thing that's just kind of a bystander is always valuations. So there are valuations needed in this process, especially when you do these agreements that you need to start to consider. And valuations are things that usually are out of your advisor's hands. It usually, in my experience, about 4 weeks in there. Usually it's always like a 4-week kind of thing. So also bake that in your timeline. So I think in the process, I just touched on, you're gonna need your financial statements. You're gonna need advisors to help you through all the complex agreements that you're gonna go through. You're going to need an Article 11 pro formas, and due to the new SEC rules, there's some cap dilution tables that you're probably going to need work with. But in a sum, that's kind of what you need on the accounting and finance side.
Thank you. Any questions about registrant filings and related matters that Carla so clearly covered? Anything from panelists?
You know, one thing I would
Go ahead,
point
Mark.
out and add, and I think Carl would agree, is that, the commission and the accounting staff there haven't always been particularly firm until after the fact on how you account for certain of the transactions. I remember, a couple years ago we had the issue where all the forward purchase agreement backstops were all had to be reclassified.
Yes.
And which resulted in a couple of hundred restatements,
Yes.
if I recall correctly, which is a restatement of your financials is ultimately a very big deal, and it impacts executive compensation, it impacts your credibility in the market. and it is a very unpleasant process to go through. I
Yeah.
think you would agree.
I think so. I mean, kudos to everybody here for coming up with really complex agreements that we don't usually see on a day-to-day basis. So, to your point on the FPA agreement, they've always had that stance. Unfortunately for all of us involved, we don't really go through those agreements really. So it was kind of the first round going through that, and then them coming back and saying we don't agree with your position that you took. So, and the warrant issue, the FPA issue, a lot of that.
Right, there was the warrant issue as well.
Yep.
And so the point is that when you're going through various transactions that are adjacent to the actual DSPAC, you've really got to jump ahead on how those transactions are going to be accounted for.
Exactly.
And really have the right advisors and the people with really sufficient gap expertise in these areas to make sure that you minimize the risk of having to do it a second time after you get a comment letter from the commission.
Yes.
Totally. Any other questions? If not, we'll switch gears and move to Finn. Let's talk about creditors' claims against SPACs generally, and what related issues should SPACs be considering?
Yeah, thanks, Steve. So in a Cayman context, credit issues come up most often during the share redemption process. And as we all know, share redemptions can take place throughout the life cycle of the SPAC. From a Cayman perspective, the most important thing to keep in mind is there's a solvency test that goes with the share redemption process. And if the directors get that wrong, there's personal liability. And in a Cayman context, certain share redemptions also attract criminal liability. So this is something people take really seriously. And the spotlight was really on this test, this requirement in the last few years when SPACs were getting to end of life and there was unbudgeted fees. So we were getting a lot of questions from sponsors saying, how do I deal with this? And there's three ways that we saw those issues being dealt with and that we're kind of seeing more recently. So first is the sponsor puts more money into the SPAC. That was never the most attractive option to the sponsors. Second was the solution that worked best, which was reaching a compromise with your creditors, and that had varying degrees of success with, I'm sure, lots of people in this audience and their organizations. What we've seen a little bit of recently is the use of termination fees, so busted deal termination fees being used to fund SPAC liabilities. So that's a nice way to manage unanticipated service provider costs. The issue
Termination agreements with whom?
with the target. So when the deal falls over, if you have termination fees left, you can pay off some of your creditors. You can also use those fees to try and find another SPAC too. So it's just kind of more fees available to the SPAC. The prickly side of things has become where there's residual termination fees and who's entitled to those. And that's a really fact-specific area.
So how does that usually work? Is the termination fees being put in an escrow? How does that work?
No, so the termination fees usually are in the general assets of the SPAC.
Of
They
the
don't go
SPAC.
into escrow. Yeah.
Okay.
So all this negotiation analysis takes place behind closed doors generally. There's been a few cases that have made it to the Cayman court, and we've been involved in those cases. But if anyone has any kind of thorny questions in this area, and there are lots of them, there's the two Michaels from Maples sitting over at that table over there. Be more than happy to answer those questions, I'm sure.
For a modest fee.
For a modest fee. Thanks, Matt. And sorry, turning that question around then, Steve, I also have a question for you, which is how have creditor claims come up in the context of SPAC trusts? And how have trustees managed such potential claims? And what legal proceedings have yielded decisions affecting SPAC trusts?
Thanks. Yeah, so as many of you know, creditors' claims have been much in the news in the last couple of years as it relates to SPACs, which has become even more interesting over the course of many years as SPACs were doing their IPOs and their filings. One of the risk factors that was recounted in numerous, and I mean numerous prospectuses was, well, there are certain cases if there are creditors of the SPAC, their interests might come in front of shareholder interests, and you should be aware of that as a risk factor. And, you know, everybody kind of took that as sacrosanct, it was really not tested until the last couple of years, and there were a couple of litigations in which we were involved. One, 26 Capital, which was in the Delaware Chancery Court, where we actually litigated on behalf of the SPAC program, if you will, and got a Chancery Court decision which made it clear that SPAC trust assets are the assets of the shareholders, not of the creditors. And that was a significant step forward in establishing once and for all that trust assets are sacrosanct and can't be invaded. There was another court decision in Texas in the bankruptcy court in a company called Financial Strategies that actually filed bankruptcy, although the principals tried to be both creditors and the principals of the company. The court saw through that and came to a similar conclusion, saying once again that the trust couldn't be invaded on behalf of the creditors. So those are significant steps forward in establishing boundaries on trust assets. There are a couple of other nuanced situations. We handled two SPACs where they reached their end of life, and we were the trustee, and suddenly we were told not to distribute, even though we were required under the IMTA to distribute to the shareholders. And I think in both cases, certainly in one, a receiver or liquidator had been appointed by the company, but not by any court, and there was no court order. And we distributed because we were required to as the trustee under the IMTA, and lo and behold, the shareholders got their money, and that was the end of it. So again, these are reassuring elements for SPAC trust holders. The quirky one out there, and I'm not sure whether there's been a final decision, there's a company called Industrial Human, where we were the trustee and we actually distributed $115 million to the shareholders at the end of SPAC life. And a year or two later, a bunch of creditors came in and sued to, quote, claw back that money from the shareholders who had received it, as if that was possible. I'd like them to go to DTC and see if they can get the money back through DTC. But that's still pending, or it's just gone away as settled. I haven't gotten the latest on that. So those are interesting quirks in the SPAC world as it relates to creditors' claims. But gratefully, the SPAC model has come through it with flying colors thus far. So stay tuned. Any questions? Okay. Hearing none. Finn, we'll throw one back to you. How are SPACs legally impacted by delayed or missed extension payments?
Thanks, Steve. So the Cayman documents in that area are usually quite rigid. So most of the bylaws that you'll look at will say if a sponsor misses an extension payment, the only option the company has is to cease its business and wind up. And that's, that's pretty clear. That's what the documents say. So what to do if you're a SPAC board, you want to continue the business of the SPAC? In practice, I think what directors the approach directors can take is to consider the late payment to have been a fault of sorts, provided the payment arrives later on. It's not a risk-free approach because you are managing the SPAC in a way that's contrary to what's required under the bylaws. So the consequences for that are being sued for breach of fiduciary duty, which obviously no one wants to, that's not a position you want to be in. But there's probably 2 points to that. One, there's very little damage suffered by the shareholders in this situation. Secondly, it's up to the board to go out to the shareholders at the next shareholder meeting and ask them to ratify the breach of duties that's taken place. So we've had lots of discussions with SPACs in that kind of area.
Well, I might disagree with you about damage to shareholders. If the extension payments aren't made and the officers of the company aren't forthcoming, the question is what happens then? And some of these companies have gone through 2 or 3 extensions with missed extension payments, and so that further underscores that indeed there are damages to the shareholders, and the question is how to rectify that. So,
yeah, I guess we're going to quite fact-specific situations. I think the only way you can rectify it is in situations where shareholders haven't suffered significant amount of damage, and where shareholders are willing to ratify the breach because they think it's been done in good faith in the best interest of the company.
got it. Any questions? You have one for me?
Yeah, well, it's the same question for you in terms of what happens practically when the late payments are missed.
Yeah, so really the question, and I raised this last year at this conference, and it's for both, I mean, it's for underwriters and for issuers counsel and other participants in the eco-stream of SPACs. What is supposed to be done when companies don't make their extension payments if they haven't reached the end of life? What's the trustee supposed to do to enforce shareholders' rights and interests? And in certain cases, sometimes they have reached their end of life, and what tools are available to anybody, including the trustee, to enforce the rights of the shareholders. And it's a knotty problem. It hasn't gone away. I've urged counsel and underwriters to come up with a solution because we don't have, as trustee, enough arrows in our quiver to enforce these obligations. So we've actually, in certain cases, urged the issuers to amend the IMTA to include an end-of-life provision in the IMTA if they don't make their payment within 30 or 45 days. But that means the issuer has to be willing to put it on the docket and the shareholders pass it, and then you go down the line. In our experience, if that happened, the company would probably say, just hold on, wait, we'll make the payment, let's go through another extension. But this goes on ad infinitum, ad nauseum, and at some point it becomes ridiculous. So it's a difficult issue, and we still haven't resolved it, although I think we're seeing fewer and fewer extensions, and therefore maybe the economics and the more robust SPAC market will diminish the problems over the course of time. Any questions on this one? If not, we're going to turn to Desiree. And how can SPAC sponsors and SPAC officers keep shareholder engagement high and redemptions low during the business combination process?
Thank you for the
Sure.
question, and I'm going to start on keeping the shareholder engagement high. And I think this is just what everyone has been saying on every panel. It's just the clear and consistent communication and transparency with the shareholders, regular updates through emails and press releases, using your proxy solicitor to run targeted call campaigns. We could reach out to the retail shareholders, funds, institutional investors, set up calls with the SPAC officers and the institutional investors, and touching on what Mark said with the redemptions. The redemptions are always going to be high, especially it's very tricky in the business combination because you don't have a lot of control over that, and the redemptions come in high, but there are non-redemption strategies available, like we have non-redemption agreements and backstop arrangements, redemption caps, and incentives, as long as they're legal, incentives, and most of all, just engaging the proxy solicitor as soon as possible to ensure enough time to get the vote. And the sooner you engage the proxy solicitor, the sooner we can help with the shareholder outreach and build that into our timeline so that we can help your team the best.
Yeah, so 100%, but as one of our previous panelists made clear, the better way of reducing redemptions is to make sure that the price is $11 or more, and then
Yes.
you're liable to do just fine on the redemption
That's
stage.
true. That's true.
Well, let me give you a follow-up question. What are the biggest missteps you've seen in SPACs, the SPAC itself make in getting to market and then ultimately managing the redemptions?
Again, with the redemptions coming from the proxy solicitor's point of view, just assume, I would say the biggest misstep is assuming that there's going to be enough shareholders at the end and that you're not going to lose most of your shareholders redeeming in the business combination, which is going to leave you, having trouble, obviously, applying for NASDAQ eligibility. Another challenge is when the proxy statement does not instruct the brokers to identify the redeeming shareholders' names and phone numbers. This is crucial information when we are having all the redemption requests coming in, and the SPAC wants to know what can we do, and I'm able to provide them with the names and phone numbers and can say, okay, here's the list, now go try to get some to agree to a non-redemption agreement of some sort. Also, another misstep would be not engaging with the firm or firms that you need to assist in adding more round lots shareholders early enough, because it can cause significant delays in gaining NASDAQ approval. And the biggest thing, again, from a proxy solicitor is keeping your proxy solicitor in the loop. The best way to plan, it would be best to pre-plan the NOBO, sending in for the NOBO requests. Even multiple dates at once in the future can save you weeks of valuable time. So keep, talking to your proxy solicitor, get a game plan on when you're thinking about, and so we can put 3 days in 1 week and find the round lots that you need.
Great, thank you. Any questions? If not, I've looked at the clock and I think we've reached our end of life, so thank you very much.